I am from Mansfield, but we've had lots of support from the folks in Crawford County in our anti-injection well work in Mansfield. In 2012, we successfully passed a charter amendment, a Bill of Rights, that prevented the construction of 2 Class 2 injection wells within our city limits. That is the primary focus of our campaign here in Crawford County. Tonight's forum is basically an educational piece on the legal aspects, on Fracking 101, just a basic overview. And our presenter for that, Melanie Houston, is running a little bit late, so that presentation will be second this evening. The first speaker tonight will be Chris Brown, the Assistant Law Director of Mansfield. And just a little bit of housekeeping. The restrooms are out the back door, women's straight ahead and men's down to the right. If you could turn your cell phones to silent, that would be appreciated as well. And the presentations will run about 15 minutes, and then we will have a question and answer period for each one of the segments. So we'll do legal issues, Fracking 101, Injection Well 101, and then we have Susie Beiersdorfer from Youngstown, who's going to Skype in from Youngstown and talk about the issues that they had in Youngstown, Ohio with the injection wells and the work that they've tried to do up there to protect their community. So without further ado, I will introduce Chris Brown, Assistant Law Director from Mansfield, Ohio.
Good evening, everyone. Like Bill said, I'm here to talk about the legality of local control issues. If you want to go ahead and hit the first slide. I'm going to kind of go through 4 major points today. Ohio law and preemption. And preemption is going to kind of be the key word when it comes to legal control of these issues. Areas of local control that are still left by the Ohio law that are not in fact preempted. Home rule authority, what that is, what it entails, and then some other more creative potential avenues to get around preemption and create other rights under a Bill of Rights, like the city of Mansfield has done, and you can think about doing that in other communities. If you'd like to hit the next slide. Preemption is just a principle that a state law can supersede or supplant any inconsistent local law or regulation. And that's exactly what Ohio's oil and gas law does. If you want to hit the next slide. It's chapter 1509 in the Ohio Revised Code, and it falls under ODNR, the Department of Natural Resources. Within that, they have a division of oil and gas, and that's hereby created under this chapter. If you'd like to hit the next slide. The division has the sole and exclusive authority to regulate the permitting, location, and spacing of oil and gas wells, of which the injection wells that I think tonight's flyer at least focused on, the Class 2 injection wells, they fall into that oil and gas regulation under Chapter 1509. There are some exceptions for Class 1, 4, and 5 that is regulated by the federal EPA. But for tonight's conversation with the fracking and the injection wells, that's going to fall under 1509. Next slide, please. I'm just going to kind of read from the code to give you an idea of this preemption. It says, the regulation of oil and gas activities is a matter of general statewide interest that requires uniform statewide regulation. And this chapter and rules adopted under it constitute a comprehensive plan with respect to all aspects of, like I said earlier, locating, drilling, well stimulation, completing, and operating of oil and gas wells, and that includes those waste injection wells, within the state, including site construction, restoration, permitting related to those activities, and the disposal of waste from those wells. So like I said, that's where we get this idea and the reason behind why the state has said, look, we're going to have a statewide comprehensive plan, and that's where that preemption part comes from. They didn't want one set of regulations in Richland County, another in Morrow County. The problem that you can obviously see is that when it becomes sole and exclusive, all powerful, it leaves no control for local communities. Local communities there have no say of where these wells will go. In fact, if you go back to that language, it even talks about the location. And we'll talk a little bit more about the problems that can create later. However, the chapter does, it leaves 2 sections available for local communities, and it deals primarily with the use of roads. And so it says, nothing in this section affects the authority granted under the Director of Transportation, and the local authorities in sections 723 and 4513. But here's the key language, is this last clause. Oh, sorry, next slide, please. I thought I was on that slide. The last clause is really important. It says, provided that the authority granted under those sections shall not be exercised in a manner that discriminates against, unfairly impedes, or obstructs oil and gas activities and operations regulated under this chapter. So as you can see, they've carved out an exception so that local governments cannot use the only two small pieces of power that have been left to them to discriminate against oil and gas companies. You know, make of that what you will. So next slide, please. So I've quoted both of these sections here, at least the pertinent parts. The first one is the power to regulate the use of the streets. That's always been something that local governments have had control over, how wide the streets are, what kind of traffic, the flow of traffic. So this becomes important when we're talking about what kind of vehicles can be transported on particular streets. So when you go through a small downtown like Bucyrus or Mansfield or any of the other local communities, there's often a truck route you've probably seen. Same idea here. If you don't want these huge oil tankers rolling right through, because it really can create a substantial burden on the infrastructure in a small community, whether it's bridges or roads, it can get tore up. I mean, especially in the summertime, just find a place where trucks sit at a stoplight, and I'm sure you've all seen the deep grooves that large semi-trucks and other industrial vehicles can make. That's the idea behind that. And next slide, please. 4513 is the other section. Again, same vein. It's written permits for oversized vehicles. So again, communities can always say, we don't want oversized vehicles to have free reign over our downtown streets. Of course, you can't use it to say, we don't want oil and gas oversized vehicles free reign. Any other oversized would be okay. That's kind of what they're talking about there. So at this point, if you're probably feeling a little bit frustrated about, you've seen now this very small amount of control that local governments have over this. There are, and there may be, a few areas in the future where there's a little bit more control. And that's home rule authority. So if I can have the next slide. Municipalities receive and derive their power and authority for the exercise of local self-government from the Home Rule Amendment to the Ohio Constitution, which stipulates that municipalities have the authority to exercise powers and adopt and enforce laws of police, sanitary, and other similar regulations that aren't in conflict with the general laws. And like we already know, 1509 is a general law that is meant to preempt anything that is in conflict with it. And you know, you guys probably have already seen this kind of things. I know, for an example, in Mansfield, anywhere in the state of Ohio, typically the recreational use of a small amount of marijuana is going to be a minor misdemeanor. Within the city limits of the city of Mansfield, it's a first-degree misdemeanor. That's an example where you can have you can have a law that is a police power in a municipality that is different, as long as it's not in conflict. There, it increases the penalty, it does not decrease it, so it's not deemed to be in conflict. That's an example to give you an idea of how home rule authority works. If you go to the next slide, please. Here's just the language from that section of the Constitution granting that power. And like I said, the little blurb I had before this almost quotes from this verbatim, that municipalities have authority to exercise powers of local self-government as long as they're not in conflict with general laws. And like I said, that means as far as the regulating, the permitting, anything like that, the location of wells, typically that's going to be found to be in conflict with Chapter 1509. But there may be good news on the horizon. If you get the next slide, please. Currently sitting before the Ohio Supreme Court is a case known as State of Ohio, ex-rel Jack Morrison Jr., Law Director, City of Monroe Falls, Ohio, v. Beck Energy Corporation. And is anyone familiar with this case? I know you. I presume some of you guys are. In this case, the City of Monroe Falls, they had basically 3 types of ordinances that they tried to prevent fracking or injection wells from coming into their municipality. The 3 types, to kind of paraphrase them, one is zoning, Another one is the traffic laws that we already talked about. And then the third type is one that are similar to Chapter 1509, where they're talking about the technical aspects of regulating injection wells and fracking wells. I thought this case is extremely interesting because it's made its way all the way up to the Supreme Court, and the Supreme Court is really homed in on the zoning portion. Beck Energy Falls has already conceded that Monroe Falls can regulate the streets. And then in some way, though not completely, if you look at the briefs and the way the oral arguments were conducted, Monroe Falls has somewhat conceded that they cannot regulate the technical aspects that are covered by Chapter 1509. But the court spent an hour listening to oral arguments based on that zoning issue. Now, as a very brief recap, I'm sure some of you have a somewhat idea of what zoning is, but anytime you lay out a city, you can imagine it's very important to set aside certain portions for residential areas only, certain portions for retail and light business, and then certain areas of your community for industrial. Because you can imagine if you have a nice residential community, you don't want an industrial whatever, whether it be heavy machinery or farming or chemical company to come in right in the middle of that residential neighborhood. You can imagine that you would have some very annoyed neighbors, whatever the industry may be. And the same would go for here. You can imagine that these wells, and I'm sure that Brian's going to have some pictures later. I'm sorry I didn't bring any pictures because I presume there'd be many going around of what these sites will look like. Oh, you don't? No? Okay, yeah, sorry. I guess, yeah. That's
we'll work. We can pull up Donna's pictures.
You can imagine these are noisy sites. You know what, I mean, just imagine kind of what an oil rig looks like. You've probably seen pictures. That's what it looks like in the middle of a field. There are these large tankers, there's bright lights, there's heavy trucks, there's heavy machinery, you know, noxious fumes, loud noises. You wouldn't want this in the middle of your neighborhood. You certainly wouldn't want it in your backyard. But that's exactly what happened in Monroe Falls. Essentially, it was in a residential neighborhood where, to be fair, there were 4 large parcels, but 4 large residential parcels, they put their properties together, and in the middle of all 4 backyards, they put one of these wells. And you can imagine that the rest of the neighborhood would not be very happy about that. So they sued, and like I said, they had those 3 principles. The 1, the traffic regulations, 2, the zoning, the 3, the technical aspects covered by Chapter 1509. And the lower courts essentially said, look, Chapter 1509 is clear. When it comes to the location of these wells, Chapter 1509 and the permitting process under the Division of Oil and Gas from ODNR, they have to say where this goes. Your local community and your local zoning ordinance, that doesn't matter. And I can tell you from personal experience, when the city of Mansfield had an injection well proposed and a permit application approved by ODNR to go in our industrial zone, the first thing when we tried to challenge it, the oil and gas company in that case, the first thing they challenged was our zoning ordinance, even though it made no specific mention of oil and gas industries whatsoever. They just jumped on our zoning ordinance right away and said, you can't tell us where to put this, don't even try. Now that case was settled on other technical matters that had to do with their permit had expired, but still zoning is really where this battle is headed. And I would say pay very close attention. We should have a decision from the Ohio Supreme Court in the next couple months. I went to the oral arguments, and I will say, I don't want to jinx it, but I will say that it seemed like a majority of the justices were receptive to leaving this idea of zoning still to the municipalities. So that would be a great thing. If you can't ban them outright, you can at least say, we're not going to have an injection well in, you know, the backyard of a residential neighborhood, like Monroe Falls did. So next slide, please. So of course, I think the next question then is, you know, well, does that mean that we can use zoning to effectively ban injection wells? Probably not. There was a 1992 case called Newberry Township Board of Trustees versus Lomac Petroleum, and that's what that community had done. Basically, they zoned their whole town residential and then said, sorry, no injection wells here in the residential part. The court found that the zoning ordinance had the practical effect of prohibiting wells in types of areas that would have usually been considered appropriate for such activity. So I think that's going to be a great boon to, you know, the frack-free movement and at least the protection of local water sources if we can at least move to a place where local zoning ordinances will be respected by some of these companies and by the state of Ohio. Right now, I think it's just kind of sad when the state comes in and says, yeah, we know you would like to say that you can't zone here and there, but we don't care about any of that. So hopefully it'll move towards that. And then, so the last thing, next slide, please. One of the other things you can do, and this will maybe take a minute to kind of fully develop what I have to say about this, but Mansfield has passed a Bill of Rights and made it part of our charter. And this is something that we're very proud of. My boss and our law director, John Spahn, pushed really hard for this. This was on the ballot. This is something that the citizens of Mansfield voted on, not just council, but this is actually now part of our charter. We have established a Bill of Rights, and I won't read, oh, this doesn't look out, look, sorry, this looks different on my computer. So I'll go through what our rights are. We have the right to sustainable water, the right to clean air, the right to peaceful enjoyment of home, right to a sustainable energy future, right to self-government, right to the people as sovereign, rights as self-executing rights, and then a list of ways to further secure and protect the rights enumerated by this Bill of Rights. And essentially what we've tried to do is create a system and a level of protection for citizens if perhaps we cannot stop, let's say, ODNR or Chapter 1509 of the ORC. If we can't stop that, we can at least create a system of rights for the people in our community to exercise in court if those rights are violated by, these companies, or even potentially and arguably the state of Ohio for not allowing us to have any kind of say in local control to begin with. Now, one of the things that I think is important to say, could you click through a couple slides and let's see what this looks like? Keep going. So, one of the things that we did and we thought was really important was that we pulled these rights and built them on rights that are already granted through the Ohio Constitution to all Ohio citizens. These are inalienable rights, redress in courts, property rights in groundwater, lakes, and other water courses, and then the right to alter, reform, or abolish government and repeal special privileges. So, as I said, while that Bill of Rights may not stop fracking in our community, it bolsters rights and it reminds the courts of rights that are already inherent and built into the Ohio Constitution that the citizens of Mansfield do have should those rights be violated. I can further say, I know Athens is working on something like this if they have not already passed something like this. I was at an oil and gas conference about a year ago, and a pro-oil and gas industry type person was giving a talk, and they were kind of making fun of this type of stuff, saying, this isn't important, it will never hold up in court. And I would disagree, because what I think is really encouraging, could I have the next slide, please? Just a few months ago, in December of 2013, the Pennsylvania Supreme Court, in a case called Robinson Township v. Commonwealth of Pennsylvania, found Pennsylvania's synonymous law to Ohio's Chapter 1509, which is Act 13, unconstitutional, because it basically did exactly what 1509 does and strips all local control and all kind of rights from the local citizens. The Pennsylvania Supreme Court found that Act 13 violated the Environmental Rights Amendment of the Pennsylvania Constitution, which guarantees state citizens the right to a healthy environment. Now, our Ohio Constitution does not have language as unequivocally strong as Pennsylvania's, but I think that where Mansfield's Bill of Rights is moving, and with Ohio's right to water ownership, that we have some of the groundwork that maybe the Ohio court could hang its hat on, or at least create, a positive movement that Ohio could get a constitutional amendment similar to Pennsylvania's Section 27. But I thought it was very interesting and encouraging that the Chief Justice for the Pennsylvania Supreme Court concluded that a direct and harmful degradation of the environmental quality of life in Pennsylvania's communities and zoning districts were affected by Act 13, which, like I said, is very similar in structure and in scope and power to Ohio's Chapter 1509. And one more slide, please. So this is Pennsylvania's constitutional amendment, Section 27, that the people have a right to clean air, pure water, preservation of natural, scenic, historic, and aesthetic values of the environment. This was passed by a 4-to-1 margin by the voters of Pennsylvania in 1971, and I think it's something that Ohio would be really lucky to have. And like I said, you could always borrow that language for your local Bill of Rights, like Mansfield did. And then my last slide is just kind of a what can I do? And as I kind of said, 1509, it does not leave a lot of room for local communities. But you can always petition your community to pass legislation or charter amendments similar to Mansfield. Personally, you know, I would say go for the gusto and go for the charter amendment because that's voted on by the people. It's not just council representatives who can be swayed one way or the other. I think you send a very clear message when the whole electorate gets to come out and vote on it. You can always write your local state representative to amend Chapter 1509 to create more local control. And I think that would really get right to the root of the problem. You can petition to an amendment to the Ohio Constitution similar to Pennsylvania's Section 27, again, getting straight to the root of the problem and providing courts an opportunity to fight Chapter 1509 if the legislature won't let them. And as a very last case scenario, if you find yourself in an area where an injection well or a fracking well is going to be placed, you can always appeal that decision of the Oil and Gas Commission as provided in Ohio Revised Code 1509.36, which provides, I didn't want to get into the details today because it's really long, but it provides a rubric and a procedure in which you can say, look, this shouldn't be here. No one in the community wants it. It's a health hazard, et cetera. It gives you the opportunity to at least be heard before the commission that grants the permits. So that's all I had for today. I know it's probably a lot of information and some of it's technical, but any questions? Okay, I'll go first here.
Are there any like chinks in 1509 where there could be a constitutional a challenge before the Supreme Court here in Ohio?
I mean,
with the could the Bill of Rights that Mansfield passed be used to challenge the revised code itself?
I mean, potentially within the city of Mansfield, right? That Bill of Rights only extends to the boundaries of the city of Mansfield. And if you kind of have a power structure of laws in the state of Ohio, you know, you've got Constitution up here, and then the ORC flows from it. And then even below that, you get your local laws. So we're kind of still under 1509. So like I said, it's more of a backdoor approach.
Backdoor. Is there anything that
Well, one of the possibilities is, like I said, with that case in the zoning. That's one. That's the closest thing that we have right now. I mean, I don't want to be negative, but 1509 it's been around for a little while, and it's seen a lot of confrontation from all types of legal groups, and they're not making a lot of dents in it. Yeah, I don't want to be negative, but right now I'll say it doesn't look good. I mean, it's a piece of legislation that's passed. It's a business regulation. It has a lot of the reasonable and constitutional certificates that business regulation needs. It has, like I said, that language in there is kind of built and tailored straight from case law, talking about what is constitutionally required to have a preemptive law. And, you know, because they say that it's something that is highly regulated, it's a general statewide interest, it requires uniform statewide regulation. Those are kind of going to be the key words that courts are using when they're determining the constitutionality of this. Like I said, I don't want to be negative, but so right now, and, you know, it's not airtight. I wouldn't say anything's airtight. All laws are written by humans, and so there's always errors. There's always going to be workarounds. But I think some of the other things that we touched on as far as zoning, as far as writing your legislator to change it, getting an amendment similar to the one that Pennsylvania has, those are the things that we'd be looking for. On Ohio Supreme Court, they could always take a tact like the Pennsylvania Supreme Court did, but one of the big problems is that we don't have something with the environmental gusto language that Pennsylvania has. We do have a right to water courses, but that's more of a property right, so you'd have to prove first probably that you've been damaged in some way, that your water's been poisoned or your property rights have been impinged on before you can begin that. But I mean, I appreciate that, and like I said, I don't want to paint a grim picture, but the problem is with that preemptive law being what it is, it's very hard to get around. And that's why, like I said, there are always things you can do. I don't think you need to sit back and feel like you're being railroaded by the ORC, but there are some things you can do. You, sir?